There are a number of differences between these two approaches. California is a little bit broader, applies to more data and more companies and more use cases, sets up its own standalone regulatory enforcement agency with rulemaking, whereas other states typically leave enforcement to the state attorney general. But the really big distinction between these two frameworks is that with respect to sensitive data, California is more of an opt-out style approach. Individuals can tell companies, do not use or disclose my personal data, my sensitive personal data for unnecessary purposes. Washington State framework, the model is much more, if you as a company want to collect or use sensitive personal data, you need affirmative, opt-in, freely given, specific, informed, and unambiguous. That's a standard most of you should recognize from the GDPR, consent from the individual. We're in a period there where 1 or 2 states would pass these privacy laws each year. Last 2 years, we've had 7 states each year pass these comprehensive consumer privacy laws. So the speed is very much accelerating. Not all of these state laws are yet in effect, but right now we're at a stage where even though we don't have that federal framework and standard, about a third of the US citizenry lives in states where there is a consumer privacy law in place.